Good afternoon, everybody. We've got 40 joined on the Zoom link at the moment, so I'm conscious of the time, so I'm going to make a start. So first of all, thank you all for attending this afternoon's tea time training session regarding the proposed repeal of the presumption of parental involvement in the Children Act 1989. This tea time training session will form part of a debate. This session, I need to let you know, is being recorded and will be available via our YouTube channel. A link will be set up on our website following the session. It's a matter for you all whether you choose to have your cameras on or off, but please do remain on mute during the debate. There will be time at the end for any questions or observations that you may wish to make. Thank you to our expert panel, which is formed of Martha Walsh, Kerish Sayer and Patrick Still, who argue for the repeal of the presumption, and Rebecca James and Nathaniel Harding, who argue against it. The panel members should be pinned on your screens and they should become larger when they speak. If there are any technical difficulties, please make a note in the chat and we'll try to resolve those as we go along. I'm sure that all of you would have noted that the government plans to repeal the presumption of parental involvement has made the headlines since it was announced on the 22nd of October. And these plans are said to mark a major shift in how the family courts approach cases involving allegations of abuse. And these changes form part of the government's plan for change, which seeks to protect children, stand up for victims and rebuild trust in the justice system. And it's understood that as part of these proposed reforms, the court will retain the powers to restrict a parent's involvement where they are deemed to be a threat to a child's safety, and this includes supervised contact, indirect contact through written communication, or no contact at all. However, we do await for the government to legislate in this respect, and we're told that this will happen when parliamentary time allows. It was this headline that actually sparked a debate amongst members via email. So this is why we thought we'd bring a debate to you via this tea time training session. So I'll hand over to the full team who have 10 minutes to set out their stall. Thank you.
Good evening, everybody. It's lovely to see so many of you. As Louise just said, I'm going to kick off now for the pro team. And it's quite right that Chambers became aware of this proposal, I'm sure as much as you did through the media. There was an article in The Guardian on the 22nd of October, which personally gave me a flashback to when I was still in law school studying for the LPC back in approximately 2007, when I read and reread for the first time, somewhat agog, that a child born out of marital rape would be presumed to still have a relationship with the perpetrator. And ultimately, that surprise and shock seems to radiate through certainly the article that was in The Guardian, and indeed subsequent pieces that have now precipitated in magazines such as Grazia. Only this week have quoted various different cases, but the case of Claire Throssell, where tragically 2 of her sons were killed when an abusive father was granted contact with them. And so here we are. The difference, obviously, between arguably naive law students and members of the public, and us now as experienced family practitioners, is that we understand there is a whole host and complexity to the different dimensions, dynamics, tensions within family systems when it comes to what contact should look like in the future for families moving through difficult times. And therefore, before we delve deeper into this legal rabbit hole, so to speak, we wish tonight to break it up on behalf of the pro team into separate parts. So Martha in a moment is going to be reading some stats and facts from the Women's Aid report, and then Patrick is going to follow up with some law, which I'm sure we'll all be pleased to hear about. But looking at it just for a moment from our own perspective as family practitioners, and knowing that amongst us there are a whole range of practitioners. Some may, for example, specialise in care, maybe in private law, maybe in finance, or a touch of all three. Just speculating how this might impact on our practices if it were to be brought in. Ultimately, in my view, and certainly I would say that the pro team's view, it will impact on all of our practices across all three of those areas. In care, for example, I rather tragically, extremely tragically, was representing a mother for a number of years, and it actually transpired that her partner went on to murder her in the course of the care proceedings. Now, that father had been having supervised contact with the child up until that point. And indeed, even after conviction, and when we were still in the course and the proceedings continued, the question mark about contact was a live one. As things in actual fact crystallised in that case, that the father himself retracted from giving meaningful instructions, and so therefore they didn't end up becoming an argument or a debate, if you like, in that particular case. But certainly from the pro side of things, that was a case where perhaps arguably reactively, I certainly felt that was an occasion where the presumption of contact should not apply. So that's an example, as I say, is how it would certainly come into our practices potentially from a care aspect. We all know from a private law aspect how we are constantly dancing a dance around contact between one parent and another parent for whatever reason. We know presently, of course, there is the presumption with, of course, caveats, which Patrick will come on to look at more in detail, and the others indeed, I'm sure, from the opposing team in a moment. But very much we can see how this potential alteration will impact on that very real tussle that we all know about in private law. But even in the context of financial remedies, I frequently am in a situation where we have parallel private law proceedings, for example, in place, and one party will be saying, but there will be contact. There is going to be contact ordered in private law proceedings because there's a presumption that it will be. And therefore we have an equal housing need. And quite often the court will flow with that because that indeed is the presumption. As we know in financial remedies, it's somewhat separate. They don't drill down into the detail as to the ins and outs. But based on that presumption, there is a large amount of assumption that happens, which certainly impacts on, as I say, even FR proceedings. So at that point, having opened up the pro points, I'll hand over to Martha, who, as I say, has got some stats and facts to support our argument.
Thank you, Karis, and thank you all for attending tonight. I think one of the things that's really important to get across is that the proposed repeal is not a knee-jerk reaction, but in fact comes on the back of decades of looking at how to make contact safe for children where there has been domestic abuse. And Women's Aid, if I can commend to you strongly, I'm sure you're all very well aware, but they have been at the forefront of leading the campaign on making contact safe for children and looking at contact in the context of domestically abusive relationships. Their most recent report is June of 2025 and sets out the history, which goes back to their first report in 2024, or sorry, in 2004, which was called 29 child homicides. And that report, and then the two subsequent reports, looked at serious case reviews reflecting on the deaths of children where their murders were related to contact. From the report in 2004, that led to the creation of PD12J, which was first on the books in 2008 and was heralded as a significant advance and protective mechanism for partners and for non-abusive partners and for children. But sadly, that proved not to be sufficient. The other thing, of course, to comment on is that somewhat ironically, in 2014, the Child and Family Act of 2014 was the legislation that introduced the presumption. So after we had PD12J, we had the presumption introduced. Sort of going chronologically at how that is reflected, the second Women's Aid publication in 2016 looked at what had happened since their first report. That report was entitled 19 Child Homicides and reflected on what had changed and reflected on the impact of PD12J. And whilst that was considered to be a significant advance, the presumption eroded part of what had been achieved by PD12J and was considered at the time to be a considerable impediment and linked to continuing child homicide related to contact. So that report covered the child homicides between 2004 and 2015. And it was, yeah, as I said again, the pro-contact culture which had embedded by that time, which was one of the major factors related to the ongoing, sadly, murder of children in those circumstances. We then, from 2016, the recommendation in 2016 wasn't the repeal of the presumption, interestingly, but rather a recommendation that the implementation of PD12J be reviewed. How to make it more robust, more effective. And that did happen in 2017. There was a tightening up of PD12J. And in fact, what it did do is make the presumption rebuttable. So that was specifically identified to address the impact of the pro-contact culture, which had become embedded by the presumption. The other significant development was, of course, the Domestic Abuse Act of 2021, which brought in a raft of measures which were really transformative or were perceived to be transformative for children and for non-abusive parents, not least of which was identifying children as victims, children who had seen, heard, or experienced directly or indirectly domestic abuse, and the protections against cross-examination. So significant, as we all know, as we encounter on a regular basis, significant provisions within that piece of legislation. And then, of course, we had the harm report in June of 2020, just preceding that. And that had been a long promised review, hugely comprehensive review. And the pro-contact culture, the court's pro-contact culture was identified as one of four overarching barriers to the consistent and effective response to domestic abuse by the courts. And then it took from 2005, and it was the harm panel recommendation was for the presumption to be reviewed. They didn't identify the repeal of the presumption at that stage, but merely recommended that it be reviewed. So this has been a staged and gradual process, and it is from that review 5 years later that we now have the proposal for review. It is hopeful, it's right to say that there are some positives coming out of the Pathfinder project. The difficulty there, of course, is that the rollout is extremely slow, and it's not clear when it's going to come about nationally and what the overall review is going to be. In the meantime, the problems persist. So the message that one gets when one looks at, and of course, just going back to the Women's Aid report, their current report is titled 19 More Child Homicides. So notwithstanding all of the measures that have been put in place to try to address, to fix, to tinker with, to make stronger, more protective, the mechanisms that are already on the books, this problem persists. The pro-contact culture persists. And what's interesting as well, from the Women's Aid report, is that one of the other factors alongside the pro-contact culture and embedded with that is the adversarial system and the rise, and they've identified the rise of parental alienation claims alongside, and the impact of that and the manipulation of the pro-contact culture by abusive partners as part of, as we all know, and we've all seen the literature, as part of the coercive controlling relationship. And interestingly, noticed that between 2016 and 2019, an increase in parental alienation claims, which is at the time where all of these measures were being put into place. And so notwithstanding best intentions to try to use existing legislation and existing provisions to strengthen the protective capacity of what we have on the books already, it hasn't been enough. And that is very much what comes out of the Women's Aid report. And you all will be aware of the other reports in refuge and equal rights that have come to the same conclusion. And then we have the government recommendation. So this isn't a one-off. This isn't just the fulfillment of an empty pledge, but rather has a long trajectory where various other efforts have tried and unfortunately failed in meeting what the capacity of the legislation. It is time now to make the boldest step yet and repeal the presumption, the tinkering around the edges, the minor, or the not so minor, the minor and major efforts to make the legislation work, make the existing provisions work, haven't been as effective as they need to be to ensure the safety and protect mainly women, though not always, but mainly women, but always children. And so we are left with the stark reality that it is the repeal of the presumption that is the mechanism that is most likely to guarantee, to the extent possible, the safety of children through the contact system. So thank you. I'll turn over to Patrick, who can give us some context with respect to the case law.
Thank you, Martha. So to start, it is, of course, important to remember that we don't have a draft bill setting out how the amendment will be repealed, or indeed what it may be replaced with. If that presumption is a bare repeal, then we might have a bit of a clearer picture. So the presumption of parental involvement, as you're all aware, is in essence the only substantive presumption conferred within the Children Act. And I would suggest that the shifting of the burden entailed by the wording of that statute, namely, unless the contrary is shown, somewhat subverts or is at odds with the paramountcy principle. It certainly detracts from the clear focus on welfare. In terms of the precedent on the long-term welfare benefits for children of having a relationship with both parents, well, those precedents both predate and postdate the 2014 amendment, which imports that presumption. And there's no suggestion that the removal of the presumption would undermine that glut of case law. As Martha's already touched upon, Practice Direction 12J is often cited as an effective check on the presumption. However, the implementation of Practice Direction 12J outside of court among other child welfare professionals is often poor. Speaking from professional experience, I've seen an abundance of Section 7 or Section 37 reports recommending progression or resumption of contact following a fact-finding hearing, where very serious findings may well have been made. And all too commonly, that analysis is based on the presumption, or certainly can be said to be, part of a contact of a culture of pro-contact. There is, of course, an argument to say that Practice Direction 12J could be better implemented, social workers could be more aware of it, and that magistrates could be retrained on it. However, I would suggest that the removal of the presumption of parental involvement is the correct step. Drawing briefly from the final report of the MOJ published this October, that report and review considered around 50 academic papers, qualitative research on experience of BME parents within proceedings, and analysis of 245 unpublished judgments. The findings were very clear. Among those headline findings, it notes that in cases with indicators of high risk, including convictions, protection orders, and findings of harm, the courts still pursued or ordered direct involvement between children and the perpetrator parent. Together with that headline, it notes that there was little evidence about the lives of children and families following those proceedings, and it is precisely that evidence post-proceedings which the review considers. Turning very briefly then to the case law, I'm going to note only one case, the case of Rio, a child withdrawal of application 2003 EWHC 3031. Noting, of course, this is a case from 2003, long before the presumption. At 6, Mr. Justice Walls sets out, unless there are cogent reasons against it, the children of separated parents are entitled to know and have the love and society of both of their parents. In particular, the courts recognise the vital importance of the role of non-resident fathers, and it continues. So in summary, the repeal of the presumption, I would suggest, places welfare back at the centre of decision-making for children who are the subject of proceedings. What it doesn't do is undermine various established case law around the importance of a relationship with both parents. What it does do is remove the shifting of this new burden that we've really only had for the last 11 years, and that is the burden to show precisely that there should not be parental involvement. I would hand over now, I believe it's to Nat.
Hello, good afternoon, everybody, and thank you for joining. Becky and I are going to be speaking against the repeal. And I'd like to start, as I started, by looking at where this is coming from. It is coming from government, and it seems to me it is a political decision to repeal the presumption of the involvement of both parents. And a cynic might say that it is something that is being done to perhaps cast this government's failures in other areas of protecting children somewhat to the side, so that the government can have really a political win. And that is certainly how I see it. I read the government's press release when the repeal was announced, and reading from that now, it says, removing this law sends a clear signal that this government is placing well-being and safety of children at the forefront of decision-making. Well, I would encourage the Justice Secretary to read other provisions, particularly Section 1 of the Children Act, the parental principle, which already does that. I would encourage him to read Section 1.3, the welfare checklist, which explicitly states any harm which a child has suffered or is at risk of suffering. That is only on the first page of the Children Act that it is made explicit that risk has to be considered. I also noted that one objection, it was Baroness Levitt, KC, has said that contact was ordered even in cases of domestic abuse. And that troubled me somewhat because as practitioners, we know not all allegations and findings of domestic abuse are equal. Some are far more serious than others. And it is only right that each individual case be considered on its merits and its facts by the court. And the court has a wide range available to it in terms of Section 8 orders. Moving just to the presumption itself, it is explicitly rebuttable. It is rebuttable in Section 2A, and it's further rebuttable in Section 1.6 A and B of that Act. It refers to involvement, and the focus seems to be on direct contact, but involvement is not defined as such. It can be indirect contact, be supervised contact. It can also be something as simple as parental responsibility. To remove a presumption that might go as far as to remove or indicate that equal exercise of parental responsibility is something that should have to be gained rather than presumed, is to my mind slightly troubling. We've heard from Martha already about some of the numbers, and it is right, of course, to say that there have been cases which have ended in tragedy. What troubles me is whether this repeal is going to have any practical implication on the ground, whether it's going to solve that problem. Martha's spoken of cases of child homicide, and it's very sad, but we're talking about 19, I think, and 29 were the numbers that Martha mentioned. In some research I did, there are about 40,000 children cases a year, more or less. As a percentage, that is very, very small. Where you have a system, be that through statute, be that through case law, practice direction, etc., that works 99.99% of the time, I would say that is a system, it is a set of laws that works. For those of us on the coalface, we know as well that this is a presumption which is rebuttable very easily. Many of us will have seen cases where no contact is ordered. Final orders are made absent contact. And now, of course, that the DAP courses are no longer available as they once were. It is more common than ever for cases to end in orders with no direct contact, simply because the work that would need to be done by someone who has been found to have committed domestic abuse is simply not possible, either financially and largely within the timescale of the proceedings, within the child's timescales. So I do not agree that it is a pro-contact culture which amounts to contact at all costs. That has never been my experience, certainly working in these courts in the Southeast, and I don't believe that really is the approach that is taken by the judiciary or magistrates when they are dealing with cases of this nature. Martha touched as well upon the toxic part of pro-contact culture, for example, with the claims of parental alienation that are made, allegations of parental alienation. Often it's said by people who are seeking to further abuse their victims through the court process. Of course, we've had recent guidance in respect to parental alienation, and that is a far higher hurdle now than it was previously. So steps are being taken in the right direction. But to my mind, there is no repeal needed because Practice Direction 12J is a more than adequate safeguard. And I've just picked out a few paragraphs in Practice Direction 12J, which I think are really important. Practice Direction 12J, paragraph 7. The court must in every case carefully consider whether the presumption applies, having particular regard to any allegation or admission of harm by domestic abuse to the child or the parent, or any evidence indicating such harm or risk of harm. That's one part of Practice Direction 12J, which makes it very clear that the court must carefully consider whether or not the presumption should apply when we're dealing with domestic abuse. We all know Practice Direction 12J, paragraph 25, that interim orders are not to be made unless it is in the child's interests and would not expose either the child nor the other parent to unmanageable risk of harm. Not even significant harm, just harm. That seems to be, on the face of it, the fact that orders must not be made, a complete flipping of the presumption. It seems there that the presumption is an order shouldn't be made unless a certain burden can be shown by the person seeking contact. And then finally, if you look at Practice Direction 12J 36, and 36.3, I think is key. The court should make an order for contact, and we're talking here about cases after findings have been made, only if it is satisfied that the physical and emotional safety of the child and the parent with whom the child is living can, as far as possible, be secured before, during, and after contact, and, so conjunctive reading here, that the parent with whom the child is living will not be subjected to further domestic abuse by the other parent. It's my experience that courts are getting better and better at interpreting and understanding Practice Direction 12J, and that risk assessments, whether they're done by Section 7 report, whether they're done by organisations such as Legally Faithful Foundation, or whether they're done by reviewing engagement with a domestic abuse perpetrators programme, are really informing the decisions that courts make. So for all those reasons, I say there is already more than adequate safeguard. And for that reason, I personally, and for the purposes of this debate, do not agree that the presumption should be repealed. I'm going to hand over to Becky now, who I think is going to talk perhaps from a more public law perspective. And I'll let her start that now.
Lovely. Thank you, everybody. And I'm very aware of the time. This is a very expansive subject that it means quite a bit to everybody, I'm sure, who is here. So I'm going to try and be as quick as I can. I thought a lot of the things that I was going to be saying they're actually summed up in an article that was written by Lucy Reed, KC, from last year in the Family Law, and it's 2024 Family Law 947 is the reference. And I know it's a year ago, but she's talking about the presumption of parental involvement 10 years on. And I think probably what I'll do is just quote from her last paragraph, where she says that she's actually pretty agnostic about the presumption being reversed, although we will have to wait and see what it is to be replaced with, if anything. I don't think that it is the solution that campaigners are looking for, and nor is it a prerequisite for achieving their goals of safer contact, even if it would somehow send a signal. We do not need to eradicate the presumption, statutory or otherwise, that contact with both parents is generally a good thing. We do need to persuade judges, or as judges, to be open to the idea that proven domestic abuse, harm suffered, and ongoing risk of harm are good reasons to restrict or even preclude contact or involvement, perhaps in more cases than has hitherto been the case. And that and this is quite important, I think, and that the process of persuading the court that this is so can be a difficult burden for victims to bear. And so we need to use our enhanced understanding and skills in relation to domestic abuse to rebut the presumption where it applies and where it is justified, and to argue for truly welfare-based outcomes which properly take into account the harm caused by domestic abuse itself, and sometimes by the family court process itself. And she says that fundamentally that's a task for the family court community and not the statute books. If you read the rest of the article, it's very insightful, I think, about where we get this presumption from, what it actually means. She basically says that the presumption is that parental involvement from both parents is a good thing, unless it's not. Because when we look at section 1, subsection 6, there are so many that effectively, if there's harm showed, or there's a risk of harm showed, then the presumption falls away. And I think that's really important to note, because effectively it has very little bite if you read it properly and it's applied properly. So that's really one of the things I really wanted to refer you to. The other thing I wanted to say was the New Law Journal had an article last week after we'd heard about the government's intentions to repeal the presumption when there's parliamentary time available. So there's always that restriction on it as well. But also it also says, which is something I think Keris referred to right at the beginning, about the government also plans to introduce automatic restrictions on parental responsibility following conviction of a serious sexual offence against a child, or where a child is born as a result of rape. And that's going to be an amendment to the Victims and Courts Bill, which seems to me a much more impactful element on the idea of harm perpetrated against children, domestic abuse, all of those things, than a repeal of this somewhat lackluster presumption. With regard to care proceedings, and I'm a care practitioner mainly, we of course we don't have a written presumption, but what we do have is the local authority. When there's state intervention, the local authority have a duty, or must allow the child reasonable contact with both their parents. And if they want to stop that, they have to make an application to the court for permission to stop it. And so within care proceedings, and of course, what it all comes down to is the local authority, the state, has more resources than the private individual does to make proper risk assessments and impose proper supervision and proper mitigation of those risks, both to the child and also to the other parent, if necessary, where there is domestic abuse, domestic violence involved, and controlling coercive behaviour also involved. So the state has the resources, which of course private individuals don't, but that may be something that the government should be looking at. rather than repeal of the presumption, but they should be looking at to giving more resources to the organisations like CAFCAS, so that they can actually carry out proper risk assessments, and there are also more resources for the private individual. So for very often, as we know, it's the mother, for the mother to have some resources available to her, so where she can be, where the risks can be mitigated if there is indirect or direct contact with the other parent, but also some risk mitigation as per the risk to herself because of that further involvement. So that's one way that I think the state intervention has better resources to mitigate the risks. There is also the Schedule 2 of the Children Act, which Part 2, paragraph 15, which says that we should promote parental and family contact with a child in care. So we have that effective presumption when the state intervenes that the contact should happen with both parents, or there should be involvement still from both parents. And also, finally, what I would also say is that we need to think about the way that things are going in care proceedings with regard to post-adoption involvement of parents. And that is certainly the President's 2 lectures, Adapting Adoption to the Modern World, and all the recent RES and all those ideas that there should still be involvement of both parents, even after the legal connection has been severed between them and the child. So it seems, in my view, it seems that in care proceedings, in adoption proceedings, we're going the other way to a repealing of a presumption where, and we'll have to remember finally that the presumption of parental involvement is supposed to be for the child's benefit. It's for the welfare of the child, and we have to think about whether or not it's still for the welfare of the child, that they should have both parents involved in their lives, whether or not that is by direct, indirect contact, or simply by having some information about the child and some say, sometimes, possibly, unless there's a reason for why they shouldn't, some input into the decisions that are made for that child. And we're all children. We all have, we've all had parents, and we all know, we all have our own feelings about our parents. But at the same time, I feel, personally, I would want to know who my parents were. I would want to also know that they had some involvement in my care as a child. So that I think that's something that we really have to consider when we're thinking about a repealing of this presumption, because it's not for the parents, it's for the child. Yeah, I better finish because we're supposed to finish all together, I think, now. But anyway, so as you can see, there's a lot to be said about both sides on this, and of course the government have proposals to do it, so it's going to happen, we hope, for some people, but when it's going to happen, we don't know.
Thank you, everybody. That was very interesting. I completely failed at keeping people to 10 minutes because it was so interesting hearing you all speak and hearing the different perspectives about it. And the questions that I had noted before we started were answered as people went along. Is there anybody that's joining us that would like to ask a question? Please do feel free to unmute and ask away. That's a no from the audience. I've just got 1 point for each team, really. And for the against team, it's, would you say that repealing the presumption is simply a step too far? Yes or no?
I would hope it's a question that we've answered already. I think that's a yes, it's a step too far, an unnecessary step. And when we look at what the impact may be on our practices, you know, and day-to-day cases that we deal with, I think over the next year we'll probably see that it's become a step too far, but that's perhaps the pessimist in me coming out.
Thank you, Nat. And for the 4 team, would you say that repealing the presumption does not go far enough?
Well, I'm not sure if I speak on behalf of all of us, but I think the repeal of the presumption seems to be an appropriate step. The report's fairly clear that what it's trying to address is essentially cultural, and it's the culture within the family law sphere of this pro-contact. It goes just far enough. It doesn't repeal or undermine any of the case law in support of relationships with both parents. But of course, if my teammates disagree with me, I'd be happy to hear from them.
Silence, Patrick. So I think that means they agree with you. So you're all right for speaking on behalf of the team. Has anybody in the audience got any questions? If not, I think we'll finish up for this evening. Not as far as I can see. If you've got your hand up, do unmute. So I can't see all of you because there's so many. Okay, well, thank you everybody for joining us for this tea time training session. I hope to see some of you joining us at our Financial Remedies conference, which is tomorrow. So thank you all and have a lovely evening.
Thanks. Bye.
Thanks. Bye.